Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. California, congratulations. Let's celebrate. That's right. You are waking up today with more personal freedoms than you went to bed with last night. Why is that? Well, because the merits panel of the Ninth Circuit has actually stepped in on the matter of Reno May v. Bonta and lifted the stay of the injunction. We'll break it all down for you so you understand what this means. But what this does mean, in short order, is good temporary news for you now. So today, let's spend a few minutes, let's break it all down, and let's talk about how Californians wake up with constitutional rights today. Okay, so the case we're talking about today is Reno May v. Bonta. Now, there is a companion case, Carolero v. Bonta. Both of these lawsuits challenge all of the sensitive places that were implemented effective January 1st through Senate Bill 2, which essentially turns the entire state of California into one gigantic sensitive area. Translation, doesn't matter whether you have a concealed carry license or not, doesn't matter how good your background is, doesn't matter how well you are trained or proficient in the use of the firearm, you really can't carry it anywhere in the state of California now. Now, as you guys may recall, this case was originally litigated in the United States District Court for the Central District of California. After oral arguments, that court enjoined enforcement of this law throughout the entire state. So all of the sensitive places that were placed in Senate Bill 2 were enjoined pending the outcome of the case. Of course, along comes the Ninth Circuit, never a good thing. They sucked it up like a big old Hoover vacuum cleaner, and the first thing they did is they issued a stay of that injunctions, which meant last week, everybody in the state of California was living without the right to keep and bear arms anywhere outside their home. Good news, the merits panel of the Ninth Circuit has accepted this case and they have lifted the stay. What does that mean? It means that the injunction that was placed on this law by the United States District Court for the Central District of California is back in effect, which means all of the sensitive places found in Senate Bill 2, now codified in California Penal Code, are enjoined pending the outcome of this case. The order of the court lifting the stay of this injunction specifically reads, the motion to consolidate is granted. The clerk will consolidate numbers 23-4354 and 23-4356. The emergency motion under Circuit Rule 27-3 for a stay pending appeal and for an interim administrative stay, the supplements, responses, and replies thereto have been referred to the merits panel, and the case is calendared for argument in April. The administrative stay previously entered is dissolved. The emergency motion under Circuit Rule 27.3 for a stay pending appeal for an interim administrative stay is denied pending further order of the court. Appellee's motions for reconsideration or clarification of the court's order of December 30th, 2023 is denied as moot. The existing briefing schedules remain in effect. Two things to take from that. Number one, the original stay granted by the Ninth Circuit has been lifted, and when the state of California asked again for an additional administrative stay, the merits panel said thanks, but no thanks. Translation, California, you are living slightly freer today than you were yesterday. Translation, you resemble something more similar to an American citizen than you did yesterday. Now, unfortunately, this is my prediction. I believe that May and Carolero are actually going to prevail in front of the merits panel. I believe they will get at least 2 of the 3 votes on that 3-judge panel. That will be fantastic news until, of course, the Ninth Circuit sucks it up, sits on it to summarily overturn it at a date later. Obviously, this case has a long way to go. Kudos to the plaintiffs on this case. You guys have been fighting like holy hell. This is a fantastic win for everybody in California. California, as you wake up today, if you actually want to take your concealed carry firearm with you, well, you may actually have the ability to do so. Listen, we'll go ahead and link up the order down below so that you guys can geek out on it for yourself. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information, it's also down there in the description box. Now, in the meantime, Let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.